Hello, welcome to my channel. Today, we are going to study Civil Procedure for the Uniform Bar Exam. We are going to study some questions related to civil procedure in the federal court system and trial motions. Prior to the question, let's learn the rule related to the first question. When a case is tried to the court, the judge must find the facts specially and state the conclusions of law separately. Now we are going to read the first question. A manufacturer sued a buyer in federal court for failing to make timely payments under the parties' sales contract. The case was tried to the court solely on documentary evidence. Immediately after the close of the evidence, the judge announced from the bench, "Judgment shall be entered for the manufacturer." And judgment was so entered. The buyer has appealed the judgment. What is the buyer's best argument for persuading the appellate court to reverse the judgment? A. The trial court erred by not providing findings and conclusions. B. The trial court erred because it announced the judgment without giving the parties an opportunity to submit proposed findings and conclusions. C. The manufacturer was required to file proposed findings and conclusions before the trial court ruled. D. The judgment is clearly erroneous because it was based solely on documentary evidence. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is A. The trial court erred by not providing findings and conclusions. This is because the case tried to the court solely on documentary, but the court did not state its findings and conclusions on the record. Thus, the buyer's best argument for persuading the appellate court to reverse the judgment is that the trial court erred by not providing findings and conclusions. Alright, you want another question? Then, please hit the thumbs up and subscribe right now. Before we jump into the next question, let's learn the relevant law first. The general rule in the federal court system is that the Court of Appeals has jurisdiction only over final judgments. Now we are going to read the next question. A patient domiciled in State Y sued a doctor domiciled in State X in a federal court in State Y. alleging claims for malpractice. The doctor moved to dismiss the action. For lack of personal jurisdiction, the court denied the motion and set discovery cutoff and trial dates. The doctor has appealed the denial of the motion. Should the appellate court hear the merits of the doctor's appeal? A. Yes, because the doctor's personal jurisdiction challenge raises a constitutional question. B. Yes, because a contrary appellate decision could terminate the action. C. No, because the district court's decision on jurisdiction is final. D. No, because the appellate court lacks jurisdiction over the appeal. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is D. No, because the appellate court lacks jurisdiction over the appeal. This is because a motion to dismiss can result in a final judgment if it is granted and terminates the action. But here the court denied the motion. Thus, the action continues in the trial court, and the appellate court lacks jurisdiction to hear the appeal. One more question? Then, please hit the thumbs up and subscribe right now. Here we go. A railroad worker's widow brought a wrongful death action in federal court against the railroad, claiming that its negligence had caused her husband's death. At trial, the widow offered the testimony of a co-worker of her husband. The co-worker testified that he had seen the railcar on which the husband was riding slow down and the cars behind it gain speed. The co-worker also stated that he later heard a loud crash, but did not turn around to look, because loud noises were common in the yard. 3 other railroad employees testified that no collision had occurred. At the close of the evidence, the railroad moved for judgment as a matter of law, which was denied, and the case was submitted to the jury. The jury returned a verdict for the widow. The railroad has made a renewed motion for judgment as a matter of law. What standard should the court apply to determine how to rule on the motion? A. Whether there is substantial evidence in the record to support the verdict, resolving all disputed issues in the widow's favor. B. Whether the widow presented a scintilla of evidence to support the verdict. C. Whether the verdict is against the weight of the evidence. D. Whether the evidence revealed a genuine dispute of material fact supporting the widow's claim. This time, if you know the answer for this question, type your answer with the reason in the comment box. I will leave the answer on my Instagram study 4 bars. Follow me on Instagram and check the correct answer of this question. I hope today's video was helpful to your bar study. If you want to study more for the UBE, don't forget to subscribe. Happy study!